Start. Under subsection 4, the court, while making an order for provision of evidence under subsection 3, is empowered to issue the same processes as it may to witnesses before it in a suit being tried before the court upon failure of persons to attend in accordance with such processes being issued to them or committing a default or refusing to give evidence or even being guilty of contempt of the arbitral tribunal, they would be subject to such like disadvantages, penalties, and punishments which the court may impose by its order on a representation of the arbitral tribunal as it can do in suits being tried before it. Similarly, while enforcing an award under section 36, the court is empowered to resort to the provisions of the CPC in the same manner as if the award was a decree of the court. The only caveat being that the enforcement of the award would have to await the expiry of the time provided in section 34 of the 1996 Act for making an application to set aside the award or the rejection by a court of a petition in that respect. The interesting aspect is, while some aspects of the procedural law are available to the court while dealing with issues arising in arbitral proceedings, both before, during, and after passing of the award, as also at the stage of execution of the award, an attempt is made by the legislature quite consciously to not to superimpose the entire web of procedural law. Therefore, while in one sense both the arbitrator and the civil court before whom the proceedings arise under the 1996 Act are free from the entanglement of any other substantive or procedural law, in respect of which provisions are contained in the 1996 Act, there is yet a scope for taking recourse to procedural law, that is the CPC, to provide greater efficacy to the arbitral process. Therefore, while interpreting the provisions of sections 34 and 37 of the 1996 Act, in our view, this aspect will have to be borne in mind. This brings us to our second question, which is the root of limited notice in derogation of any known principle of law, in our view, having regard to the fact that there is no limitation in section 34 of the 1996 Act, which disempowers a court while entertaining a petition under section 34 of the 1996 Act to issue a notice limited qua some or one of the grounds led out to challenge the award. It cannot be held to be contrary to the provisions of the 1996 Act. The procedural limitations, if any, in an appeal arising from a decree in a suit cannot be applied. The reasons for this is that the award under the 1996 Act, upon its pronouncement, eo instanti, attains the attributes of a decree which lies dormant till such time either the period prescribed under section 34 for setting aside expires, or a petition under section 34 is rejected by the court. Having said so, the proceedings under section 34 do not necessarily take the shape of execution proceedings para para. as the remit of the court dealing with a petition under section 34 is much wider than that of an executing court, while executing a decree, which emanates from a suit stop, a court while adjudicating upon a petition under section 34 is not limited to the mandate of section 47 of the CPC stop. In other words, the court's power of scrutinizing an award at the section 34 stage is not limited to examination of issues, such as, inherent lack of jurisdiction or that the resultant award is a nullity, as this would be the remit of the court if it was examining objections to a decree obtained in a suit stop. Therefore, by its very nature, an award which is a result of culmination of proceedings before the arbitral tribunal, excludes by implication, the application of provisions of section 96 and order 41, rule 11 of the CPC stop. The judgments, which the division bench, took recourse to in the simplex case to provide a plank for its conclusion that a petitioner under section 34 would have to be, either admitted or rejected, is in our view, flawed stop, there being no limitation on the court's power to issue limited notice, what requires to be examined is, would a limited notice affect the interest of an aggrieved party stop. In our view, the answer to even this question would have to be in the negative stop. The reasons for this is that, while issuing a limited notice on one or more grounds, the court would necessarily have to give reasons, in respect of those grounds, it is not inclined to issue notice stop. As long as reasons are provided, a party cannot have any grievance whatsoever stop. The reasons, set out for rejection, would form a basis for preferring an appeal by the aggrieved party stop. It was argued on behalf of the appellant that this would entail a possibility of an aggrieved party having to file more than one appeal stop. This possibility undoubtedly cannot be ruled out, as possibly the following scenarios could arise stop. There could be a scenario, the grounds on which notice is issued, are ultimately found by the court to be sufficient in the award being assailed, and, therefore, no cause may arise qua the petitioner to carry the matter in appeal stop. There could also be a situation, where upon, hearing the opposite party, the court may come to a conclusion that the limited grounds on which notice was issued, even those do not pass muster stop. In such a situation, the petitioner could carry the matter in appeal, both with respect to the initial order whereby the court refused to issue notice on grounds which were agitated before it, as also qua those grounds on which notice was issued, but on hearing the opposite party, it refused to interfere with the award stop. There could be a third situation, where even though the petitioner succeeds in persuading a court to assail the award on the grounds on which notice was issued, stop par.